I wanted to welcome everyone to our chamber convener meeting. We provide information for business owners and professionals, as well as community leaders and community stakeholders. This is a program of the Surprise Regional Chamber of Commerce. For those of you who are first timers to a chamber event, we represent 6 cities in the West Valley, those being El Mirage, Sun City West, Surprise, Waddell, and Youngtown. My name is Raul Sada. I'm the president and CEO of the chamber. And I wanted to thank everybody for joining us on today's Zoom call, and also our YouTube and our Facebook followers. If you're joining Zoom today, feel free to use the chat feature if you have any questions for our distinguished panel. Also, before we get started, I wanted to thank the 200 businesses that signed on to our one-click letter that went out to state legislators and the governor requesting additional protections for Arizona small businesses in regards to vaccine mandates and the associated fines. So thank you guys for doing that. We appreciate it. Well, let's go ahead and get started. We have a full program ahead of us. What I'm going to go ahead and do is introduce our distinguished guests as well as our moderator, and then we'll switch it on over to Chris. Today's moderator is Chris Herring. He's the Director of Strategy and Operations for the University of Phoenix. Chris also serves on the board of directors for the chamber, and he also chairs the Government Affairs Committee. So thank you for that, Chris. Our 2 special guests that we have on today's call are no strangers to the Chamber of Commerce. Both these individuals still hold the chamber world record for the most watched YouTube videos. The video that we did on recreational marijuana in the workplace was viewed over 27,000 times. So that's going to be a very hard record to beat. Our first special guest today is John Baltus with Jennings and Strauss. John counsels private sector clients as well as government agencies, including Arizona legislature, on a broad range of employment law and labor relations matters. With over 30 years of practice, he has represented clients in proceedings before the Equal Employment Opportunity Commission, U.S. Department of Labor, National Labor Relations Board, Arizona Civil Rights Division, Arizona Industrial Commission, Arizona Department of Occupational Safety and Health, and the Arizona Department of Economic Security. Our other distinguished guest, Joshua Black of the law offices of Joshua Black. Joshua regularly represents clients in both state and federal court and appears in agency proceedings before the U.S. Department of Labor, the Equal Employment Opportunity Commission, Arizona Attorney General Civil Rights Division, the Federal Merit System Protection Board, and the National Labor Relations Board. If Joshua looks familiar or sounds familiar to you as well, it's because he has made several media appearances regarding employment law on Fox 10, 3TV, NBC, ABC, and KTAR, just to mention a few of the media appearances. So with that, Chris, I'm going to go ahead and turn over the conversation over to you and let you get started.
Thank you, Raul, and thank you, John and Joshua, for being here again with us at the chamber. To kick us off, before we even get into the questions, I'm going to just address something with our viewers. You might be viewing this live. You could be viewing it on YouTube later on. But as we go through today, the chamber is not going to be making political statements today. We recognize this is a highly charged political topic right now. The chamber has come out with a statement and action that we've taken on this. As Raul mentioned, we do have an action alert that's active with a letter to the Arizona legislature and the Arizona governor, urging them to take action to protect small businesses against the harmful effects of the federal vaccine mandates. So you can go to our website, you can read that just to see what action we're urging, and that is our official stance on the vaccine mandates that have been issued. So as we go through today, you're not going to hear me making political position type statements. We're going to be talking about this from a legal point of view, from an economic point of view, and we're here to get expert advice from John and from Joshua in the legal realm, so that employers and employees can better understand this issue as it regards to how it might be enforced, the impacts of it, what recourses are available, all of those things. So if you're here and you're looking for debate or you're looking for politics, you're not going to hear as much of it, but you are going to get a whole bunch of hopefully very, very useful information that'll make you better informed on these topics. So with that said, I'm going to go ahead and kind of lay the groundwork. So both of you know that this is something that's going to be extremely disruptive to small businesses, to medium-sized businesses, to large businesses. It really doesn't matter what size your business is. A change of this nature and the way that it's being implemented or proposed to be implemented, there's no way for it to be anything but highly disruptive. So the kind of thing that we hear as the Chamber of Commerce is that you have a CEO, you have an executive at a company, they've got over 100 employees, they're going to be affected by this mandate. And they're concerned because they know it's going to eat up a ton of resources. It's going to eat up a lot of time because they are expected now to enforce this. And so they're expected now to make sure that every employee that works for them complies. And that means they have to somehow enforce employees disclosing vaccination status. And if the employee refuses, then they have to figure out what action to take. They have to figure out, how do I audit if they're getting tested like they're supposed to? How do I report it? How do I store that information? How do I keep it updated? What do I do if they're a day late on that information? Is there supposed to be penalties? Do I have to come up with a disciplinary policy? All of this takes a lot of time, which means a lot of money that, to be honest, they probably don't have. Most businesses aren't sitting on cash saying, hey, in case the government does something crazy, I'm going to come in and just have all the resources I need. You stack that on top of our current employment situation where the majority of small and mid-sized businesses, and again, even large businesses, are understaffed right now. They can't even meet the minimum they need to meet their projected business. And so you've got understaffed companies, and you've got this new mandate that's coming in, and these employers, these business leaders are saying, this is not sustainable. Even in a good situation where I'm fully staffed and have everything I need, I can't meet this. And I'm not even there right now. So literally some of them come to the chamber, throw up their hands and say, what am I going to do? So that's the business side. We're going to start there. So with our first question, the vaccine requirements from a Supreme Court perspective, what do we know about just the legality of the federal government stepping in and saying this is now required? And I'll let either of you take that one.
Well, I'll start. There's one, I think, reported case that we can go back and reflect on. It's the Jacobson v. Massachusetts case. And it involved a fellow who had a long history of adverse reactions to vaccines. And he was faced with a smallpox vaccine mandate, and he filed a lawsuit essentially to secure an exemption from the vaccine. And the Supreme Court ruled against him and basically held that he had to be vaccinated. The case sort of has, if you're looking at Supreme Court precedent for purposes of sort of assessing where we are today, it kind of cuts both ways. It has limited value. The court decided it in 1905. So this is long before we had laws like the Americans with Disabilities Act and so on. In other words, the legislative and regulatory landscape was completely different back then, and in fact, non-existent. If Jacobson, this fellow, filed that lawsuit today, he'd clearly be eligible for an exemption under the ADA because of his medical circumstances. So because of the era in which it was decided, it isn't really relevant to us for purposes of assessing whether someone really could secure an exemption, because the laws that provide those exemptions now didn't exist. The fundamental holding in the case, though, I think is a little different. It's more generic, and it is kind of important for purposes of the Biden administration mandate. The court held that our individual liberties as citizens under the Constitution sometimes have to give way to police power, particularly in situations involving emergencies, like what we have on our hands now. And I think the Biden administration probably will be able to use that holding in more of a generic sense to deal with a lot of the constitutional challenges that are being made to the mandate, including Attorney General Brnovich's challenge that Arizona filed. Arizona was the first state to file a lawsuit challenging the mandate. So The Supreme Court precedent doesn't have a lot of depth for us in this situation, but there is some limited value to it in that respect.
Okay, thank you. And Josh, did you have anything you wanted to add on that one, or do you think John covered it pretty well there?
I think John really covered it. Like John said, I think a major factor that is going to be examined by both sides to the debate is, does the individual liberty outweigh the public good of requiring a vaccine? And people fall on both sides of that answer. Reasonable people, arguably can say yes or no to that. But I think that is where the mileage is going to come, is from that understanding that, hey, we do have an ability as a society to force society's will on individuals sometimes, if it's to protect the general population.
Well, thank you for that. I think our viewers will find it interesting that there isn't as much precedent as I think some of the older cases may on the surface appear to give. And so I think that's extremely relevant. I know I've seen that case mentioned in Jacobson. So I think that's very relevant to what we're talking about. And I can tell you personally, I never thought I'd have a story like this, but we have a close family friend is a kindergarten teacher, months ago, got the first vaccine shot and had a severe allergic reaction. Has never had that before with any vaccine, and didn't anticipate having it. So of course, has to go to the hospital and what's going on, and said, okay, we can't give you another shot now because this has happened. And so, now you've got a kindergarten teacher that's saying, I'm not choosing this. I tried to get vaccinated. Now I got to go get tested every week now. And so that, I think those are the things that the individual employees are looking at. And of course, the school districts, teacher shortage and other things, they're saying, what do we do here? How much time do we invest in this? And it's very personal to the individual, and very impactful to everyone involved. So I know this is going to come up, and I'm interested to see what the rulings are on the Brnovich case, since it was the first. So let's talk about the labor aspect of this. LAPD is a high-profile one right now. I think United Airlines is another one I just saw that just came up. LAPD, somewhere between 2,000 and 3,000 employees, not necessarily all officers. They could have other roles within the department. Are citing religious objections, which has the appearances maybe this is an organized effort within that organization to use this religious exemption. Washington State, there's the same thing. You have thousands of workers that have done this within the state of Washington, and others across the country. You're hearing the same thing. The United example was a little bit different. There's a very myriad of reasons that hundreds of employees there are claiming it, but major organizations, major global brands, state organizations, local municipalities are running into this issue of exemptions. So, they're having to deal with it, and they have a lot of resources. LAPD has a lot more resources than a business out there with 100 employees. And so they've got more lawyers, more HR professionals, they've got, state resources, and they're having a hard time dealing with it. So how do you determine whether somebody has a genuine religious exemption? How does a business go about that? How would they even get the resources to say, what do I do? Like, an employee comes to me and says they have a religious exemption, or all of my employees come to me and say they have religious exemptions. What do you do? What are you required to do? What can you do? Or should they be calling one of you?
Well, this is a great question, because I think most of us have heard about, the two principal exemptions, the disability exemption and the religious exemption. And for a lot of people, sort of learning about it through the media kind of superficially, that's where the understanding stops. And so it really actually is, Chris, really important, I think, for your members and the viewers to understand the answer to this question that you've posed, which is, what do you really have to show as a worker in order to secure a bona fide exemption based on religion? If you as an employee come to your employer and say, hey, look, I consider myself a pretty religious person, and I kind of view my body as a temple. And I just don't feel comfortable putting this vaccine into my body. And so I want an exemption based on religion. That is never going to cut it for purposes of securing the exemption. What an employee has to show in order to secure this really it involves three things. The worker has to be a member of a religion. The religion has to have a specific principle that's at issue, meaning I can't be treated this way, I can't be vaccinated. And then the employee or worker has to have a sincerely held religious belief about that principle. Those are the three things the worker has to show, okay? So for example, a Jehovah's Witness or a Christian Scientist can legitimately say, I'm a member of that religion and my religion prohibits me from doing this. Specifically, it prohibits me from taking this vaccine. And I sincerely believe that. Okay? If that person presents those facts to the employer, then the employer has to consider the exemption. Then you go through a secondary analysis of whether it can be accommodated, would it constitute an undue hardship, and so on. But those are the three things to consider. What's important to note here is that religion, for purposes of this three-part test, doesn't need to be a mainstream religion that we're all familiar with. What the Supreme Court has said is that as long as it is a belief system that occupies the same place in a person's life that traditional religion does for others, it can constitute a bona fide religion. So as long as you know what I've just explained, whether you're a business or a worker, now you should understand what the basics of what's required in order to secure an exemption based on religion. And if Josh wants to chime in to sort of put a finer point on some of that, I'd welcome that. But that's basically how it works.
Yeah, I think John's completely correct. The finer point I would add, or just something I would build on, is that I would even go so far as saying just being a Jehovah's Witness, for example, or Christian Scientist is not necessarily going to be enough. Most of the mainstream religions that we know of or that we're familiar with aren't opposed to this vaccine. And so from what I've seen, you're really having to find someone who almost is more of a member of a fringe belief system or fringe religion, because mainstream religions, Catholicism, for instance, there was some concerns early on about how vaccines were developed. The Pope ended up coming out and saying, look, get vaccinated. That's clear. If it's for your safety, get vaccinated. That's a major percentage of the world's religious population right there. And as John I mentioned earlier on, Protestant, general Christianity, hey, I'm a Christian, my body's a temple. You can cite 1 Corinthians all day long, and I've heard it a lot. And I can ask people, 1 Corinthians? Because I know, and it's not because it's not a valid opinion, but it's because I know it and we've talked about it and we already know that's not going to meet the threshold. Your body being a temple is great, and that can sincerely be your religious belief, but that's not the same as I don't get this vaccine. And so I think you're going to have a hard time as an employee convincing your employer that you have that sincerely held religious belief and that you connect all those dots that John was talking about. That one, I feel, is going to be less common than the disability or health reasons that people might want to opt out.
Well, I think it comes down then, and this is, this is where my mind goes, and I've hired hundreds of employees. I don't think I've known the religious belief of more than a handful, because maybe they've done something to overtly disclose it. As an employee, how much am I required to, do I have to go in with like, here's my sacred text and here's my statement of belief and here's how long I've been, like what, so, on the employee side, what are you really expected to do to go and somehow now prove your religious beliefs beyond, like you said, a verse in the Bible? And then on the employer side, from the way both of you just described it, are the employers expected to know? I don't know all the religious beliefs of a Christian Scientist. I would have no way of knowing if that is a belief or isn't a belief. So am I supposed to now go hire an expert on world religion to figure out, like, does this religion exist? And do they really believe this? What is the burden as the employer? If an employee comes to me, am I supposed to go audit that religion to figure that out? What is the nuts and bolts of that from those two angles?
Josh? The answer is you're just going to have to research it yourself, basically. I don't think it would have to go as far as hiring an expert on world religions, but I mean, the internet's a great resource. I think it might not be as difficult as you think, unless what the person is claiming to be part of, like Josh said, is so fringy that there's not a lot of information on it. And I think in that case, I would turn it around on the employee and say, you know, I've taken a look, and I'm not able to find what you're describing to me. So that we can continue with this dialogue, can you bring me some resources so I'll understand what you're talking about? I think it just has to be a dialogue, right, Josh? I mean, it just has to work that way.
Yeah, absolutely. It has to be a dialogue. And there are certain questions I think that you as an employer can present to the employee to try to help kind of make that determination. So I've worked with some companies and they have an exemption request form, and I have a version that I use. If a company doesn't have it and I'm working with an employee, you know, we might use that to kind of just get ahead of the game and say, hey, look, here's the important questions. This is what I know you're going to want to know, and here's how I back it up. And I do think it's really the employee's burden, at least initially, to show the employer that this is sincere and it is a real religious belief. So questions like, how long have you been a member of this belief system? You know, does this belief system have any sacred texts that talk about, you know, vaccination? Is there a religious leader you follow who, you know, has posted articles about this? You know, you can kind of go through and I can provide a sample too for members after the call, because like I said, I have just kind of a general template. But I think having something like that as a business is a great way to make sure that you get the details you need without risking that a manager is going to accidentally ask something inappropriate, or that someone's going to consider it inappropriate. If you can give them a form with the questions and say, great, we're happy to consider, don't pass judgment one way or the other. You know, we're happy to consider if you can fill this out as completely as you can. That'll help us evaluate. And I think you can ask some of those deeper questions about the religion and ask them to provide documentation. And that kind of puts the burden on them. If they don't come back with much, I think you're going to be a lot safer to say we're not providing an accommodation. If they come back with a mountain, then you probably do want to hire someone like John or myself to take a look at it and be sure in that instance, because the alternative, if you make the wrong decision, is going to be more than 20 minutes with a lawyer.
So we spent a little bit of time on this issue, and I think it's so relevant, and that's why I've taken a little extra time here. But one last thing on this: should employers be expecting guidance from a regulatory standpoint? Will OSHA be publishing guidance on what they want to see in this area from employers?
Well, you know, the September 9 announcement from President Biden was just sort of like, it was skeletal, you know, and one way that he's avoiding constitutional challenges, especially when we talk about separation of powers, is that the way he orchestrated this is he's not mandating it from the White House. He announced it and he said, okay, I'm telling the DOL and OSHA to create an emergency rule and enforce it. So he shifted the entire responsibility for basically implementing it and enforcing it to other people. And through that process, when we see the emergency rule come out, which I'm surprised we haven't yet, I don't believe it's out yet, there's going to be presumably a lot of deep detail about things like this. Whether it'll address this particular question, I don't know. But we're waiting on a lot of information that is going to follow from that generic press conference where this whole concept was announced.
Great. There's tons of great information here. I know there's employers that are going to be watching this that have this question. And so, Joshua, if we were going to follow up with you afterwards, like we always do, and any assistance on just moving that process forward. I know our small businesses want it and need it. So thank you both for that. It was a good discussion on the religious exemption question. let's talk more about accommodations, hardship from an employee, and the relationship with the employer. So, the vaccination is one option, right? The routine testing is the other option that's available. So if an employer is to come to the chamber and say, hey, I've got disadvantaged employees, a lot of them have special accommodations, right? And regardless of what those might be, but they've got accommodations that, how they get to and from work, their mobility, things of that nature. They can't just go out anytime they want and run off to another clinic to get a vaccination, or they can't run out and get tested regularly. They don't have the ability to do that. Is the expectation then to kind of say, that's not my problem from the employer, which hopefully with much more compassion than that. But is there a responsibility or an obligation from the employer to provide an accommodation for this, since it's not necessarily a work requirement as much as, again, is an OSHA regulation? So what is the burden on the employer in that situation? Is this an American with Disabilities Act situation, or how should this be handled?
Well, I can start an answer on that, and John can jump in certainly with his thoughts. But I would say that this is something that the employer is going to have to treat just like any other accommodation. That's something they're going to have to consider and evaluate. If these people have to be tested, or if they have to go through this process, I'm going to have to accommodate into my either schedule, into their schedule, into how the cost of that's being displaced. There's accommodations that are going to have to happen. And so I think employers have a little bit of a gamut of options that they can choose to be in compliance with, with general OSHA guidance. But ultimately, I think just like as if someone determined, hey, there's asbestos in this workplace, the employer might have to take on additional financial responsibilities due to OSHA making some kind of finding. I think I look at it kind of like that if there is extra expenses, that OSHA has the ability to kind of force an employer to take those on. John, what do you think?
Well, this kind of begs, I agree with everything you just said. It begs a larger question, though, and it goes back to the sort of bare bones, generic nature of the press conference when Biden announced this. And this deals with the issue of who bears the expense for a lot of the logistics and the cost for this structure that has been set up, that Chris has been talking about, how it's going to be burdensome on businesses. When Biden, I've been sort of studying exactly what he said, and he talked about the mandate for the vaccine, and then he said, as an alternative, the worker will then have to provide to the employer proof of a negative test twice per week. It was interesting the way he framed it. The worker has to provide to the employer the proof of the negative test, because the big question that has not been answered here, and the media has been contacting the White House, OSHA, DOL. No one's commented yet because nothing's come out. Who bears the expense for the testing, for example? Who's going to have to pay for all this testing for all these people twice a week who don't want to get vaccinated? Because that alone can cripple a business. Like you were saying in the beginning, Chris, administratively, cost-wise, and everything else. What I infer from the way he worded it is, and I might be completely wrong when this comes out, but if you just draw an inference from the way that he worded it, it communicated to me that the worker will have to pay for the testing. If the worker has to provide the negative test, doesn't it make sense then that the worker is out there getting the test, bringing it to the employer, paying for the test? And I sort of see it as kind of like the NFL solution to the problem. Make it so onerous and so difficult on the people who don't want to get vaccinated that they'll just give in. And if you say to an employee, the emergency rule came out, you have to pay for the 2 tests a week. And healthcare is not going to pay for it because the test is not being given for a medical reason. It's because of a government mandate. The employee is going to say, I can't afford that. And then the employer is going to say, well, according to President Biden, then I either have to fire you or you need to get vaccinated, unless you qualify for an exemption. So this whole question of cost, logistics, and expense, that's one huge thing we're waiting on to hear from OSHA and DOL on.
All right. Thank you very much on that. Let's change to a more niche topic here. It will affect tons of employers, but is very specific. Let's talk about the idea of union representation. Does any element of collective bargaining here come in with this? If you've got more than 100 employees and there's a collective bargaining agreement that's been agreed to, there's a contract in place. Does this have to be renegotiated? Does this supersede existing contracts? What's in play there?
So that's a good question. And like most things in the law, I would say it's going to depend on the facts and the specific scenario. For most union represented employees, they have a bargaining agreement that limits the ability of their employer to implement new discipline or to go through certain negative job actions without it going through the bargaining process. And so I think the first step that the company would have to look at is, what exactly is our COVID policy going to be? Are we saying that if you don't get a vaccine that we're taking some negative action? Are you firing people? Are you, removing them from jobs? Or are you just accommodating them in some other way, like giving them testing? So I think that you'd have to be very careful, and that the odds are that if there's any kind of recourse, which I think there would be in order for any policy to really have any teeth to it, you would probably have to go through that collective bargaining process. I think that there's a couple exceptions to that general rule. And again, that's where, the unique circumstances would come into play. But if you have a waiver in your bargaining agreement that says your employer is allowed to make certain changes or adjustments when it comes to safety concerns, which I guess is pretty common. Employers are given that freedom sometimes within the contract to say, hey, if we need to make these certain adjustments and it's because of something that's related to the health and safety of our workforce, we don't need to go through the bargaining process. And so I understand that to mean that there's a possibility there that they could get around the collective bargaining process if you have that waiver built in. Another scenario would be if there's some sort of precedent, if the bargaining unit had an established practice of allowing the employer to make these types of changes. I think that one's a little less certain, but if in the past, for instance, there was other safety mandates or flu vaccine mandate or something along those lines, and the bargaining unit hadn't spoken up, I think there could be some potential claim there, perhaps that that prior precedent would allow them to do it again. And John, you may have even more knowledge than I do on that. I don't know if there's something that you'd want to add.
Well, I would just say that clearly, let's sort of imagine a situation where this mandate takes effect. Businesses that have less than 100 workers that want to implement a structured COVID vaccination policy, I think would clearly have to bargain on it with the caveats that you've described. But the businesses that are affected by the mandate, 100 plus, are going to have a pretty good defense if they roll it out and say, hey, everybody, you either get vaccinated or you bring a negative test to us twice a week. And if the union says, well, you got to bargain on that, my position or the position of the employer probably will be, no, we don't, because this is the law. And so, I mean, that's the way I think it's going to pan out in terms of bargaining. It's going to depend on the size of the business once this thing becomes effective.
Yeah, I think it's interesting too. I mean, collective bargaining doesn't typically happen quickly.
No.
And
no.
Will this be relevant before some of those things are settled? Is a question I would have. So, very, very interesting. I did not know what the responses from both of you would be on union action and collective bargaining. So, great information. Thank you. So, the idea of privacy, we haven't really talked about it yet. We brought it up a little bit with the religious exemption question, but there's been a lot of, conversation. HIPAA gets thrown around all the time. I think there's some misconceptions on the employee side. I think most businesses have a little better handle on HIPAA since they have to deal with it and they have a really big regulatory burden there. But what is the privacy rights from the employee? And then what is the burden to protect that employee privacy from the employer? And where this, I think, has come about is if I'm requiring some employees to get tested, am I therefore de facto disclosing that they are unvaccinated to their coworkers? And have I violated their privacy by showing that they're part of this process and therefore I'm telling everybody they're not vaccinated? What's the burden there on the employer and what's the right of the employee?
So I can answer that question. I think that, well, those are two questions, and the answers are fairly straightforward. I think that with an employee's health information, and you mentioned that employees often go to HIPAA and they may have a misunderstanding of that. In reality, there's a provision in the Americans with Disabilities Act that talks about employee health information and how employers need to store that. And the main rule or responsibility that employers have is that personal confidential health information should be stored separately from the employee's regular file. So there's this idea that we want to make sure that health information is kept confidential as much as possible, but it can be disclosed on a need-to-know basis. And so that's where I think the question comes in, okay, well, what is it that you're disclosing? Are you taking steps to keep it private? Ultimately, your business has to run. You are able to require that folks get this testing. So clearly you can require, hey, they've got to leave. And if it was my business and I'm requiring testing, I'm doing it during business hours because I don't want to run afoul of any wage issues or concerns, saying that maybe they're working while they're out there, or liability if they're driving. For me as a business owner, I would do it during their work. So I think that with all of that said, I think that the employers can say a lot. They can say a lot as long as it's need to know. If you're saying, hey, if you can't get the vaccine, you need to submit this documentation. That documentation can be looked at by more than one person. I don't think it needs to be shared with everyone in the company, but HR is probably going to see it. Your manager is going to see it. The legal counsel may see it. That's perfectly allowable under the law, I would say. If the employee is, vaccinated and you have that record, you can have that. And if a manager needs to know because you're determining we're going to have a meeting and, do we need to mask or not? Is everyone vaccinated? That could be something manager may need to know. But again, it's not something people aren't going to be wearing their vaccine card with their ID badge. We don't want to go there.
Yeah, the only thing I'll add to that is, folks watching this may know who I'm talking about. Some of our sitting members of Congress don't even understand what HIPAA does. There's huge misunderstanding about HIPAA, which really relates more to external disclosure of information than internal. Really, what this issue relates to is what Josh explained, which is this is an ADA issue. The ADA says that for health-related information, it should be kept in a separate locked cabinet away from personnel files. Right. And this type of predicament came up at the very beginning of the pandemic for a lot of my clients, because when we did the plans, the response and remediation plans for employers, we made clear that if someone tests positive, you send them home, and then you don't run around to all the coworkers saying, Joe tested positive, were you near him? What you do is you talk to Joe and you say, who were you around? And then you go and you ask those people he identifies, but you don't tell them Joe has the virus. Well, for small businesses, it became kind of silly because they'd say, well, I only have 18 employees and Joe's the only one who's not here. So by doing this, I'm basically going to be telling, and I'm like, I know, but this is just the way you have to do it. So I think as long as you pay attention to the strict requirements of the ADA about where to keep the information and who gets to see it on a need-to-know basis, you should be fine. All the agencies that enforce all this stuff are being very flexible about the realities of the experience that we're having.
Well, I know that's going to be eye-opening to some of our viewers, right? I've said a few times, there's good information coming out today, and I know that I've heard tons of people say, "Oh, it's HIPAA, it's HIPAA, it's HIPAA," and same thing. HIPAA has to do with medical records from medical personnel and hospitals and such. And you're right. And I, in my job for the last decade, have had to deal with ADA, the processes we've created, the policies, all of these things. So, yeah, it can get confusing because you think, well, I don't have a disability because I'm getting a COVID test, but it's the protections and where they come from under statute. So,
right.
Great information that I know is very helpful. Okay, so OSHA, we brought it up once. I know you were waiting on it. I feel like you were like chomping at the bit to get there. So OSHA, does OSHA have the resources for this? Does OSHA have the resources to enforce this at this level? I'm just gonna leave it there. That's the question.
And the answer is no, of course not, because this is theoretically going to affect 80 million workers. OSHA doesn't have enough boots on the ground with clipboards running around to be knocking on the doors of businesses saying, "Hey, did you do this? Did you do that?" It's impossible, right? But so this invites sort of a slightly larger discussion, which relates to a new development that we were talking about before we went live today. And it involves the reconciliation bill, the 2,500-page reconciliation bill in the House of Representatives that was just passed out of committee and went to the floor this week. Within the 2,500-page reconciliation bill, on page 168, Speaker Pelosi buried some provisions that increase by tenfold the OSHA fines for noncompliance in this type of situation, okay? And this relates, I think, Chris, to the letter that the click that you talked about and the appeal that you're making to the governor about, resources for fines. Biden talked about a $14,000 per incident fine. The fines now, if the bill passes with these provisions that Pelosi embedded in it pass, the fines are $70,000 for the first violation if it's willful, and up to $700,000 for a repeat violation. $70,000 to $700,000. Now, here's why it's important in terms of OSHA resources. It involves the concept of what we call deterrence. And deterrence is a notion that stands for the proposition that if you make a punishment or a consequence so severe, the person who's considering acting to trigger that punishment or consequence will think twice and maybe not act. This comes into play with capital punishment all the time. The capital punishment people, depending on who you talk to, say, capital punishment is not so much about punishing individual criminals. It's about creating the prospect of a severe consequence so that the would-be criminal who's considering committing a capital offense won't commit it. And that's what these fines, if they are implemented, are designed to do. The administration knows there's not enough resources to enforce it. So what would you do? We'll make the fines so astronomical, they would cripple or bankrupt a business in a lot of cases. The businesses then will comply on their own. We don't have to have the OSHA inspector running around checking on things because of the deterrent effect of the fines.
Yeah, and I said at the beginning that we won't be making political statements, so I'm going to sew my tongue back together since I've bitten through it. That's yeah, it's amazing sometimes what the government gets away with in terms of onerous and detrimental policy. So that's all I'll say about that. The chamber has its position on how we are hoping things will go about. But great information. I'm going to guarantee you, John, probably 99% of the people that are going to watch this do not know that on page 168 of that bill that is in there. So, and I actually I've seen some things come out of the reconciliation bill. This is on this page, is on that page. I have yet to see page 168 come up. I'm not going to be surprised if it does, since I do know we have some lawmakers, federal and state, that do participate with the chamber. So, all right. A little more niche questions, and we are getting close to the end of our time here. And it's been amazing how much info. I often tell people, hey, it's a 45, 50-minute webinar. You don't got to watch it all. If they don't watch all of this, they're just missing so much relevant information that's just going to help put good, correct, accurate information out there, since there's so much conjecture right now on these issues. Let's talk about providing proof of vaccination. I think this is a straightforward one, but I know people are asking it. You know, an employee has to get vaccinated to comply, and you're supposed to ask for proof of vaccination. We've actually seen this for some high-profile people. In the NBA, there's been some high-profile examples of people that have been vaccinated, not provided proof. And the question is like, well, what do you do? Because they're not in violation of a policy, but they're also not proving it necessarily, or maybe they're not proving it to the right people. What do you do as an employer there, and what is the responsibility? It's, you know, if you fire somebody and they turned out to have been vaccinated, what goes on? Neither of you want to take this one?
Hey, Josh, you're on mute.
So I think that you have some options as an employer. Ultimately, you're going to need to decide what battles you want to fight, I think. I mean, if you have an employee and you're down to the point that they are vaccinated, but they just won't show proof, I guess at least they're vaccinated. So at least, you know, if that's part of the concern, they're not bothering the work group. I do think, though, that theoretically, you could ask them for a fitness for duty examination. And I think that that's probably where employers would go. If somebody is out of work for a medical reason, there's this idea that your employer can say, hey, before you come back, we want you to have what we call a fitness for duty exam at the employer's expense. And just make sure that you're in good health. You know, the idea, if someone got hurt, they're coming back to work, I don't want them to get injured worse. I want to make sure that they're really ready to come back. And often people aren't. You know, a doctor assesses and looks at what their medical condition is. My thought would be, if they're not able to show that doctor proof of vaccination, then they're not fit, because you have these requirements that people have to be vaccinated. And so he has to prove that to somebody. If he can prove it to the medical doctor and they look at it and say, okay, I say you're fit for duty, then I think you're good. And that's probably how I would try to get around it.
Yeah, I think that one I can guarantee will come up. There'll be people that do not want to provide the proof, but have taken the appropriate action. And I think it's great advice, Joshua, to say, you know, how many battles are you going to fight? If you're getting the results you want, you know, you might come to a level that might be sufficient. So, all right. And this is one that I think that we may have mentioned, but the idea of what happens when you get fired. I have seen some things on this actually in the news. The impact of unemployment, both the employee and the employer, right? An employee makes an unemployment claim, an employer receives an unemployment claim for an employee that's been terminated because they were not complying. Either they refused to get vaccinated and they refused to get testing. There's no exemption. You know, everything's by the book, so to speak, here, as much as it can be. Impacts there to unemployment claims with termination?
Well, I think it's going to change. You know, when all this started, it coincided with the enhanced unemployment benefits, right? Basically, at least in Arizona, what Governor Ducey said is that DES is going to handle on a case-by-case basis an employee's objection to being vaccinated. We're not necessarily going to be following the ADA test or the religious exemption test. They're going to look at all these things on a case-by-case basis. And frankly, I think there was a tremendous amount of flexibility. If a worker said, I got fired because I didn't get vaccinated, or I had to leave because they were forcing me to get vaccinated, I think by and large, when the enhanced benefits were in place, those people were getting benefits. I think the enhanced benefits are over now. And I think we are getting sort of to the end of this process, however you want to describe it. Biden says our patience is wearing thin. I think at this point, those people who are either exiting or getting separated over a vaccine issue, provided there wasn't a valid exemption that wasn't met, probably are not going to get benefits going forward. And that's I guess that's my forecast for it.
Okay. Yeah, and I think that's a question people have. And I've seen some other legal, I don't want to call it legal guidance because I don't think there's enough information yet to give legal guidance on it, but prediction might be a more appropriate way to say it. So
Yeah, I
Hey,
agree.
well, I'm going to go ahead and give both of you a chance to give us final
Chris.
thoughts. Do you have something there, Josh?
No, I was just going to say, I agree with John. I think that they would really, I think going forward, if it's a policy that's in place and an employee is not willing to comply, the analysis is going to be, is it because of a medical reason? Is it because of a religious reason? If not, then you're willfully disobeying your employer's direct orders. You're violating, your employer's best interest. And I think that that person's not going to qualify.
Yeah.
Well, final thoughts from both of you, then I'll make a couple remarks and Raul will close us out. But Josh, since we're with you, do you have final remarks you want to make on this topic?
Yeah, I would say, everybody, from the experiences I've had with employers and employees, it seems that everybody is trying to do what they think is right. It doesn't seem that there's some agitators, right? Always, but for the most part, it seems that whether people have a solid background for what they believe or not, they're really acting on their personal beliefs. So it's a situation that makes it a little bit more dynamic than a typical policy infraction. Typically policies are black and white and we as a society agree on them. This is something that it's going to be controversial. It is controversial. Just be thoughtful about what you do, make sure that your policy, I would say, is one that you stop and think before you take actions, before you take corrective actions, especially consider how this will affect you, because it's not just, hey, you need to go today. And if they say no today, it's a problem for today. If they feel you're discriminating, if it's an accommodation issue, this could be an ongoing trouble and problem for your business that you really don't need. And that's the biggest resource drain that I see, quite honestly, is if you've got to start getting lawyers involved because there's disputes. That's where you're going to have a lot of expense. COVID tests are inexpensive relatively. Having an attorney draft up a document's inexpensive relatively. Having someone send you demand letters and say that they're going to sue you and have lawyers go back and forth for 6 months. That's where I think COVID could cost employers money from my perspective. So I would say, just be cognizant of the decisions you're making. And if you do have a concern, it's definitely cheaper to talk to an attorney before you make the decision. Reach out to someone like John or myself, or go online. Even that was something, Chris, you mentioned. Obviously, you can't trust everything you see online, but if you put some basic analysis into it and some basic scrutiny, at least maybe that'll give you a direction, and that can even further narrow what you need to talk to the lawyer about. It can confirm, yeah, this is a gray area, or, oh no, this is just fine. This is not something to worry about.
John, final thoughts?
Yeah, I would just say to all of you, keep your ears to the ground, because we mentioned this at the beginning of the talk. There have been a slew of lawsuits filed over the constitutionality of this mandate. And if the Biden administration isn't successful in challenging some of these, we could see some very interesting developments. And if the people who are filing the lawsuits, including our Attorney General, can get one federal district court judge somewhere in the country to enter an injunction and stop this, this whole landscape is going to change. And it could change really quickly. And, depending on who you talk to, some people say that they think it's highly likely this is going to happen, and some people say that there's no chance at all that it will. The predictions are all over the map. But you can look at Josh's website, you can look at our website, you can pay attention to the media, because these will be significant developments if they do come to fruition, because all of what we talked to today could potentially get put on hold, but you won't know it unless you keep your ears to the ground and pay attention to what's going on.
Well, thank you both. I want to end with this. We get questions all the time. Why should I join the Chamber of Commerce? Why should I support the Chamber of Commerce? Well, obviously, we bring you things like this, which we believe are helpful. I know today that I learned things that I didn't know, and I'm moderating. And so we got to do research to prepare for these, to understand the issues, what's out there, what's important, what's relevant. And I learned new things especially when we have both of you on from an attorney perspective. Things we learned today is ADA versus HIPPA, which I think a lot of people didn't understand the difference of protections under each of those. What is the three-part test for proving a religious exemption exists? What is the real Supreme Court precedence, and what's relevant, what's not? What's the responsibility of employers if they're asking you to get tested? What's the best practices as an employer if you're asking employees to get tested? These are all extremely relevant things. So this is something that we do as a service to our business community, which is why we encourage you to support the chamber. And the other side of it is we do advocacy. That's my primary role as chair of the Public Policy Government Affairs Committee for the Chamber of Commerce. We reach out to your federal lawmakers, to your state lawmakers, to the governor, to the attorney general. When we meet with them, we talk with them, and we advocate and we share these stories and say, this is the issue. This is what we're going to see happening to employees, to employers, to our businesses, to our local businesses, to our economy from these actions. And so we represent you there, and we speak with a loud voice. As we said, hundreds of you signed on to our letter to the lawmakers, urging them to take action. So if you haven't in the past, consider it in the future, supporting the chamber, becoming a member with an annual membership, and you'll be supporting our work here. So thank you both. Raul, I'm going to give you a chance to say one last thing, and we'll end it there.
Yeah, thank you, Chris. Awesome presentation today. I do want to do a shout out to Arizona Representative Frank Carroll. It's a very interesting question you put here, and we don't have to answer it, but it is thought-provoking. Should the courts rule in favor of the greater good argument, would such an opinion extend to other rights? And I think, what that kind of speaks to me is, when is enough enough? And so hopefully, Representative Frank, you've been inundated with some of our emails, and that that the business community is very concerned about this particular issue. So with that in mind, I want to thank you, Chris. I wanted to thank John and Joshua for your input today. If you guys have any handouts that you'd like to share with me, I'd be more than happy to forward those to everyone who's registered on the Zoom call. So again, on behalf of the Surprise Regional Chamber of Commerce, I'd like to thank everybody for attending today's convener event. Thank you, and have a wonderful week. Goodbye.
Thanks, everybody.
Thank you.